Get ready for the dictation. Start. In the case at hand, the court below has taken note of the fact that the revisionist was not only named in the FIR, but he was also assigned a role in the incident. The testimony of PW1 and PW2 as being indicative of the complicity of the revisionist have also been referred. Upon considering the settled legal position with regard to the exercise of powers under Section 319, the court below has passed the order summoning the revisionist. The FIR version as also the evidence before the trial judge being indicative of the complicity of the revisionist, though not arraigned as an accused in the charge sheet, it was open to the trial court to form a view that the revisionist be tried together with the other accused, and for the said purpose summon the revisionist in exercise of powers under Section 319 of the Code. The broad principles which have been laid down for exercise of powers under Section 319 of the Code underline the object of the enactment that the real perpetrator of the offence should not get away unpunished, and in a situation where the investigating agency for any reason does not array any culprit as an accused, the court would not be powerless in calling the accused to face trial. Rather, it would be duty of the court to do justice by punishing the real culprit. The test which has been laid down with regard to the degree of satisfaction required for invoking the powers under Section 319 is one which is more than prima facie case as exercised at the time of framing of charge, but short of satisfaction to an extent that the evidence, if goes unrebutted, would lead to conviction. The power to proceed under Section 319 has also been held to be exercisable in respect of persons though named in the FIR but not charge-sheeted, provided the court is satisfied that the conditions provided under the section stand fulfilled. Section 319(1) of the Code envisages that where, in the course of any inquiry into or trial of an offence, it appears from the evidence that any person not being the accused has committed any offence for which such person could be tried together with the accused, the court may proceed against such person for the offence which he appears to have committed. The word evidence used under Section 319(1) of the Code has been held to be understood to refer to the evidence recorded during trial and also any material that has been received by the court after cognizance is taken and before the trial commences, to be utilized for corroboration and to support the evidence recorded by the court. The evidence recorded by the court during trial is thus to be accorded primacy and for the purpose of exercise of power under Section 319 of the Code would have to be given weight over the material which was collected during the course of investigation. The contention which has been sought to be raised, placing reliance upon the material collected by the investigating officer during the course of investigation for the purpose of exercise of powers under Section 319 of the Code, thus cannot be accepted. The power under Section 319 of the Code to summon even those persons who are not named in the charge sheet to appear and face trial being unquestionable and the object of the provision being not to allow a person who deserves to be tried to go scot free by being not arraigned in the trial in spite of possibility of his complicity, which can be gathered from the evidence during the course of trial. The order passed under section 319 of the code summoning the revisionist does not contain any material error so as to warrant inference. The aforementioned legal position has been considered in detail in a recent decision of this court in Adesh Tyagi versus State of UP and another. Counsel for the revisionist at this stage submits that he does not dispute the aforementioned legal position with regard to the scope of exercise of powers under section 319 of the code and states that the revisionist would submit to the jurisdiction of the court below and seek bail. Needless to say that in case any such application for bail is moved by the revisionist, the court below would be expected to dispose of the same in accordance with the settled principles of law. Subject to aforesaid observation, the revision stands dismissed. Stop.